Hello, my name's Julian Savulescu. I'm the Chen Su Lan Centennial Chair of Medical Ethics and Director of the Centre for Biomedical Ethics here at the National University of Singapore. It's a great pleasure to welcome Professor Udo Schuklenk, who is a Research Chair in Bioethics at the Ontario Research Chair in Bioethics at Queen's University and also a member of the Philosophy Faculty. Udo and I did our PhDs together at Monash University. We did our PhDs together at Monash University, and Udo has been instrumental in the liberalisation of Canada's assisted dying laws. Udo, over
now
to
we're
you.
Talking. All right. Well, thanks, Julian, for the introduction, and thanks everybody for. No, don't hold your breath. It might be really bad. So applaud afterwards, or don't at all. All right. So I'll tell you what the plan is. Some of you will know, or many of you will know, that Canada decriminalized assisted dying. There was a Supreme Court decision just about 10 years ago, give or take. And since then, there has been internationally a lot of talk about how Canada has gone down a slippery slope from something that may have been desirable at the time to a situation where everything is entirely out of control, which is a standard slippery slope argument against the liberalization or the decriminalization of assisted dying. So my objective today is actually really basic. I tried to explain to you why that is not the case, why there has been no slippery slope in Canada, and if anything, the regime that we have in place today is still not as liberal as it ought to be if we were to take the criteria that were laid out by the Supreme Court of the country seriously. And I do all of that as a philosopher, so I stand to be corrected by the lawyers in the room at any time. The other remark I want to make before I get started, I got into this assisted dying thing, and I really call it the assisted dying thing in a really strange way. I had no agenda as far as this whole issue is concerned until I was asked in 2009 to chair an international panel of experts to write a report on end-of-life decision-making in Canada. That's how broad the theme was. And we were asked or invited by the Royal Society of Canada, which is kind of like humanities type Academy of Sciences in the country. So I agreed to do this, and since then I have developed firm views, which I didn't have before. That probably made me a good chair of this thing, but it also might explain how I got into it. I just wanted to start off saying that. So, without further ado, because I will be talking a lot about how our regulatory system evolved, this is not really an ethics talk. I will make a couple of ethical points that I think are pertinent, but really I want to explain to you how the country got where it is today, and next time you read something in the papers about how bad things have gone out of control, at least you have a bit of context. And if I have achieved that, then that's fine. That's all I try to do today. So in 2011, after 2 years of really fairly intensive work, our expert panel published this report on end-of-life decision-making, and we did recommend at the time that the country's criminal code be modified to permit assistance in dying in certain circumstances. The certain circumstances did not include any restriction like terminal illness, for instance. We are much more concerned about people who experience a life that they do not consider worth living. In other words, they experience an unbearable quality of life by their own definition. That was the objective. Now you can say fortuitously, but given the circumstances, that would be the wrong word, obviously. But at the very same time, a case was starting to wind its way through the court system in Canada, and Kay Carter was one of the plaintiffs. Now, Kay Carter was diagnosed in 2008 with a thing called spinal stenosis, which is a condition that is resulting progressively in the compression of her spinal cord. By mid-2009, her physical condition had deteriorated to the point that she required assistance with virtually all of her daily activities. She had extremely limited mobility and suffered from chronic pain. As her illness progressed, Kekada informed her family that she did not wish to live out her life, as she called it, an ironing board, lying flat in bed. Fast forward to 2015. In 2015, the Supreme Court of Canada decided that sections of the Canadian Criminal Code that criminalize assisted dying unjustifiably infringe on Section 7 of the Charter of Canadian Charter Rights, and as they describe it, as Supreme Courts are wont to do, of course, are of no force or effect to the extent that they prohibit physician-assisted death for a competent adult person. Now I ask you to really focus on this, because if you miss this one point now, not much of the rest of what I will be talking about will make any sense to you. So this one is really important, namely these two criteria that the Supreme Court laid out there. The first is that the person in question must be a competent adult. Now, this already has important implications for mature minors. As far as the Supreme Court are concerned, they are not included. The second question that arises when you say a competent adult person, whether or not that includes advanced directives. At the moment, advanced directives are still out in Canada. They're not included. But here, importantly, that this person is clearly consenting to the termination of life. That's the first criterion. And then there's only one other criterion, that this person has a grievous and irremediable medical condition, and that can be an illness, a disease, and quite importantly here, or a disability that causes enduring suffering that is intolerable to the individual in the circumstances of his or her condition. That's also important, because what matters here is a subjective view on someone's quality of life. You make your own decision on whether your quality is worth living or not. It is not for professionals to second guess that ultimately, beyond a competency, a capacity assessment of this, to find out whether you really made an informed decision, right? Okay, so the Supreme Court then, and I don't know whether this is just in this case or whether this is always the case, but basically government was given 1 year to draft legislation to give effect to this judgment. And this is what they came up with. Of course, the person has to have a grievous and irremediable medical condition, but that is only met if all of the following criteria are met: that the disease is serious and incurable, that they're in an advanced stage of irreversible declining capability, and I might want to say you can't find that standard, for instance, in the Supreme Court, amongst the Supreme Court criteria, that the illness, disease, or disability, or that state of decline causes them enduring physical or psychological suffering that is intolerable to them and that cannot be relieved under conditions that they consider acceptable. What this means is patients cannot be required to take particular courses of medication that professionals might think is appropriate when they think that is just too much for them. And thirdly, and fourthly, their natural death has become reasonably foreseeable, taking into account all of their medical circumstances, without a prognosis necessarily having been made as to the specific length of time that they have remaining. So when you just compare these two boxes here, you can see immediately that the legislation that was put in place by Parliament and ultimately became the law of the land was unconstitutional. Why was it unconstitutional? Because suddenly there had to be such a thing as natural death becoming reasonably foreseeable, which was interpreted, as in many other countries, that death needs to occur within 6 months, give or take. I wrote at the time, and call me arrogant as a philosopher who knows nothing about law at the end of the day, but I wrote an editorial commentary in one of our national quality papers, the Globe and Mail, and said, this is unconstitutional, start donating to these activist organizations if you're unhappy with this, because they're robbing us of our constitutional rights. There have been a number of court cases indeed since then, as you would expect. The last one perhaps the most important one to my mind anyway, Truchon versus Canada and the Attorney General of Quebec. Here what happened is that we had two individuals with severe disabilities that were not life-shortening. That is the important bit. These people were not terminally ill by any definition. They argued that the eligibility criterion, natural death has become reasonably foreseeable, violated their Section 7 rights to life, liberty and security of the person, and their Section 15 Charter right to equality before and under law and equal protection and benefit of the law. So Truchon had cerebral palsy. 3 of his limbs were not functional at birth, and he subsequently lost the use of the 4th. But yeah, he could have continued to live for many years with a quality of life that, in his considered judgment, was just not worth living under the circumstances. So this is when a court found that this reasonably foreseeable, death reasonably being foreseeable, criterion violated, in fact, the charter rights of individuals with disabilities whose death wasn't reasonably foreseeable. And you will recall in the Supreme Court judgment, disability was specifically mentioned as an eligibility standard. The other thing that was interesting is that the judge confirmed at the time that individuals with mental illnesses were in fact also not excluded under Carter. And I just want to draw that to your attention, because when you think about these two criteria, it is very clear that somebody could have decisional capacity, have some mental illness, I don't know, a refractory depression for crying out loud, I've written on this particular issue, and decides that their life is not worth living, and they maintain that over time, then they would really meet the two criteria that you saw in the first or second slide with the Supreme Court criteria, right? Now, you can imagine, of course, this would be super sensitive stuff here, thinking about giving access to people with mental health issues and no other issues to a medically assisted death. So that's super controversial, and for reasons I will be going into in a moment, that is of course also true with regard to people with disabilities, where the disabilities are not life-shortening. So this is how this looked like in Canada then. My favorite conservative columnist, Robin Urbach, at the Globe and Mail, she has an undergraduate degree in journalism, wrote Euthanasia for Babies. Canada finds itself sliding down a slippery slope on MAiD. This was in 2022. I can assure you that nobody other than Robin Urbach suggested that babies should be euthanized. Why? Well, because babies have no capacity to give informed consent. There was no debate over any of this. Anyway, so this is what we had in our national papers. The next one then is by some guy, Andrew Phillips, a columnist of a more left-wing newspaper, the Toronto Star, but also national paper. And he opinionated that Canada is going too far with medical assistance in dying. The danger of abuse is becoming ever more apparent. I don't even know how they got to this euthanasia thing, but the Phillips thing at least, and I'll get some more into the nitty-gritty details here, much of this had to do with the success of the introduction of medical assistance in dying, from my perspective as somebody, of course, who is in support of the system that we are developing slowly but steadily. So this is how the numbers are panning out in Canada. 2016, it was introduced, I don't know when in the year, somewhere in the middle of the year, October, whenever it was, it doesn't really matter. And there has been a fairly consistent increase in the number of people who receive assistance in dying. And the blue column, I don't know whether you can read this, but the blue column are people who meet actually the standard natural death is reasonably foreseeable. And the vast majority of those, as in any other country in the world, are people with late-stage cancer. Not all of them, just to be clear, but the vast majority of them. And there is this very small number of cases. When you look at 2021, when this became for the first time really available, when natural death is not reasonably foreseeable, and of all the MAiD cases in Canada, this is about 2.2%. And in 2022, it increased to 3.5%. And I just want to be clear, I have no doubt about this increasing further. 2 remarks. The first is, I find interesting that when these debates arise, you typically find people whose intuition is assistance in dying is wrong. To them, this is evidence of a slippery slope. There's ever more people using medical assistance in dying. To those who have entirely different intuitions like mine, I'm surprised how low those numbers are. So whether or not there is a slippery slope cannot be pinpointed by looking at those numbers. They could be 10 times as high. You still wouldn't know whether there is abuse occurring. For that, you need an entirely different set of evidence. But the fact that numbers increase really is meaningless. And I just wanted to mention this because this is what you would find in many of the public contributions to this topic, that people think, oh, look, the numbers are going up. You see there is a big problem. Well, for that, you have to be opposed to it in the first place. So when you think about slippery slopes, and I do this really quickly now because thankfully this doesn't apply, but basically in bioethics when we teach slippery slope issues, we point out that there's 2 types of slippery slopes. One is a conceptual one where the criteria are sufficiently fuzzy as to open the door to abuse, and the second one where the idea is that once we step on a slippery slope of decriminalization, bad, unwanted things will inevitably happen. Maybe not necessarily because criteria are sufficiently fuzzy, but for other reasons. Now, why is it that none of this is applicable to the Canadian case? Well, the primary reason for this is really, when you think about the Supreme Court criteria and where we are today, then even today, the regime that we have in place is more restrictive than the Supreme Court criteria. So if then the country goes about changing legislation in order to make more people eligible, as you will see in a moment has happened, and I suspect will continue to happen, then this is just a consequence of the Supreme Court of Canada having made a decision of basically pointing to very permissive eligibility criteria. That's the fundamental reason, and it's really important to understand that. What happened is that we had a government in place that basically started off, maybe not wrongly, with very conservative criteria, because it's the first time that you do that as a country, right? But that was unconstitutional. The courts found that, and I just want to take you now on the rest of the journey, if that's okay. So Canadian courts have, of course, had a close look at slippery slope arguments, because if there is really evidence of a slippery slope from any of the other jurisdictions that have decriminalized assisted dying, you would have reason to raise red flags and think about, well, if we have such a system in Canada, how can we ensure that these mistakes don't occur here? What I'm quoting here on this slide are really comments from the judges in various court cases here. One of these, the first judge basically that wrote the blueprint kind of for the Supreme Court judgment. You know, there's always like a prior judge, obviously, so it doesn't start with the Supreme Court. And she wrote kind of like a book-long report, and she considered carefully the expert evidence regarding slippery slopes in permissive jurisdictions. Now, what's a permissive jurisdiction? Basically, you can define it as a jurisdiction where terminal illness is not an eligibility threshold. Think Netherlands, think Belgium, the usual suspects in Europe. And she concluded that this evidence serves to allay fears of the practical slippery slope. The evidence does not support, in fact, the conclusion that since the legalization of assisted death, there has been a disproportionate impact in either Oregon or the Netherlands on socially vulnerable groups such as the elderly or persons with disabilities. And our Supreme Court subsequently noted that this trial judge, after an exhaustive review of the evidence, rejected the argument that adoption of a regulatory regime would initiate a descent down a slippery slope into homicide. And Truchon, which is years later, neither the national data in Canada or Quebec nor the foreign data indicate any abuse, slippery slope, or even heightened risk for vulnerable people when imminent end of life is not an eligibility criterion for medical assistance in dying. So much of the debate then, both in Canada, I think, and internationally, has turned to this issue that I might want to, if you're looking for a label, you might want to describe it as social determinants of health. And I just would encourage you to maybe just look up this website by this disability rights activist group, very radical people, not dead yet. These are people who I quite genuinely believe think that euthanasia is a scheme designed by society to get rid of them. There's no other way of putting it. And this is why I would encourage you to really look this up so you understand the kinds of anxieties that people with disabilities, for instance, experience, many people with disabilities experience when it comes to assisted dying. In their view, disability should be seen as a variety of human existence, a mere difference that is unproblematic in its own right. Or, to put it in their own words, it's never the disability itself that could render a person with a disability's life not worth living, but rather it is the social determinants of health. Right? Society not providing the services in a timely fashion that are required in order to ensure that such a person can live a life that they consider worth living. And this is how this panned out in our media. There's a man in Montreal who sought a medically assisted death due to his home care conditions. I don't know how you media work like here, but our media certainly all the time raise red flags about the quality of our social care system, of our care system for elderly people who are unable to look after themselves, and so on and so forth. Then there's a woman with various disabilities. She actually received a medically assisted death after her own futile bid for affordable housing was declined. So I'm just flagging this here because I'm not denying that there are some serious issues here, okay? I'm not like trying to gloss over and say everything is hunky-dory in the country, quite to the contrary. As far as I'm concerned, I think the empirical evidence, when you look at it, or you try to look at it fairly or neutrally, whatever you want to call it, it does support the view that both disability as well as mental illness can reduce people's social determinants of health, which is resulting in a lower quality of life than would otherwise have been the case. At the same time, there can also be no question whatsoever that there are suboptimal services, but then the solution, I think, to this is obvious. You significantly increase available healthcare resources and social service resources to assist such individuals. But here's the question that I'm asking. What if a society does not do that? How exactly are these people any better off by saying assisted dying for you? No, not until all these services are in place. Because what drove them to ask for an assisted death, even if what motivated them were these social determinants of health, I cannot see that there's any benefit that they would derive by us, society, saying a medically assisted death cannot be made available to you until we have sorted out a really great system. Because what if that system never comes? Then the life that you did not consider worth living, you still do not consider worth living. And I do appreciate that that might be controversial, and I'm very happy for us to discuss it, because I do not understand this whole argument, basically. That's what I'm trying to say. I cannot see that patients are better off for not having that choice, even if they were driven by an unjust society to request it. But yeah, I appreciate that that might be controversial. So here's what the courts made of this. I know it's a long slide, and I read it really slowly. I can't be more precise than the judge here, so I literally just read something to you from the court judgment, because I think it's quite illuminating. Because those who are opposed to assisted dying frequently use terminology like, we have to protect the vulnerable, like the people that I have just talked about, okay? And what the court basically said is, the court said, we cannot possibly accept this concept of collective vulnerability. Here's an ethical point made too, just to be clear, not just a legal point. The court cannot accept the concept of collective vulnerability suggested by the attorney generals here, because the broad protection that results therefrom is too general application of a precautionary principle. Vulnerability should not be understood or assessed on the basis of a person belonging to a defined group in bracket, of people with mental illnesses, for instance, but rather on a case-by-case basis, at least for the purposes of an analysis under Section 7 of the Charter. So that means for government, basically, it would be impossible to say we have to protect the vulnerable, so therefore we remove their agency, we exclude their participation in this process, basically. What the court is saying, it could well be that some of these people really need that kind of protection, but you have to show it for every single one of them if you want to trample on their rights. This is not the default. So in other words, it's not the person's identification with the group characterized as vulnerable, such as a person with disabilities, indigenous persons, or veterans, that should bring about the need to protect a person who requests assistance in dying, but rather the person's individual capacity to understand and consent in a free and informed manner to such a procedure based on his or her specific characteristics. So in the court's view, we cannot, in the name of the principle of protecting certain persons from themselves or of socially affirming the inherent value of life, deny medical assistance in dying to an entire community of persons with disabilities precisely because of their disability. That is what the legislator is doing indirectly by providing wide-ranging protections of certain groups instead of implementing strict structural conditions to ensure that such persons are well protected should it deem that appropriate. That's the other point the court is making. The court is saying, the court is accepting that there might be the need to protect people that find themselves in the circumstance that I've just described, right? But what they're saying is basically, you have to figure out how to protect them better, but you don't do that by just saying, we remove agency for all of you, and that's the end of that. You have to do it, again, you have to prove it on a case-by-case basis. The point being made here, collective vulnerability cannot conceptually be used as a basis to refuse medical assistance in dying. So the plaintiffs here belonged exactly to this category of people. And they want to be given the choice to decide for themselves. And the court agrees with this. To do otherwise could lead to discrimination against persons with disabilities on the sole basis of their disability. These people are full citizens and consequently have the same rights as all other citizens, especially those that involve making decisions of utmost importance to their bodily integrity and dignity as human beings. Respect for their individual freedom that is expressed thoughtfully, freely, and clearly also contributes to the affirmation of the inherent value of their lives. So what I find interesting about this is just sort of a side brief commentary here before I then move on, is that proponents of these restrictive access regimes, to my mind at least, contribute to something that's really ironic, because we have tried for decades to remove stigma from people with disabilities, from mental health issues, right? And here we turn around and say, you can't make any of these choices for yourself. Not today. So essentially, they advocate, and so we stigmatize exactly these same people all over again. Get right back to basically where this all started. So essentially, they advocate to remove such patients' agency because they disapprove of the end-of-life choices that some of these patients would predictably make. And these arguments, I think, also fail to respect the lived experience of some people with disabilities or severe mental illness who insist that their suffering is not caused by their condition, that their suffering is caused by their health condition and not by social determinants of health. And that's another important part. I think activists on both sides have been fairly opportunistic in terms of how they instrumentalized disability rights activists, for instance, like Not Dead Yet. The biggest changes in our laws have all been brought about by people with disabilities going to court saying we want those same rights as everybody else. And on the other side of the fence are groups like Not Dead Yet saying no, this must never happen. And I just wanted to flag this as an issue. When you think about representation, who do you take to be the representatives? And does it even matter what a loud activist group thinks? When you look at surveys of opinion polls of how these people with disabilities think about assisted dying, it's very clear that the vast majority of them want exactly access and the same rights as everybody else, even if they have concerns about the social determinants of health, which I think is a powerful argument, don't get me wrong. So the argument then regarding social determinants of health, I think, fails for the same reason the argument for instance, regarding palliative care failed. And I don't know, those of you who follow debates on assisted dying will know that one of the arguments that always comes up in the armament of those who are opposed to assisted dying is the argument that, well, palliative care is not perfect, there's gaps everywhere, when people need it they can't have it, so people would prematurely ask for an assisted death. And here's how the trial judge Smith, what she observed in Carter. She said, the argument that legalization should not be contemplated until palliative care is fully supported rests, as Dr. Hans van Delden is a geriatrician and a medical ethicist at the University of Utrecht Medical Center. It's really a form of hostage taking. That was his expert witness statement. In other words, this argument suggests that suffering of grievously ill individuals who wish to die will serve as leverage for improving the provision of adequate palliative care. And this is exactly what's happening, in fact. And again, the question has to be asked whether or not these are not choices people should be able to make themselves, as opposed to pushing them into this corner by removing their agency. And so the question that I keep coming back to is, how would Trishon, for instance, have been better off for having his ability to choose MAiD removed from the end-of-life options that were available to him? I think that is the fundamental, most important question here. Unless we at the same time, as a society, or he individually, or some rich person, whoever, Elon Musk, would be able to change his quality of life to such an extent that he considers it worth living, then how is he any better off by having his agency removed? I just can't see that. Don't worry, I won't go through this, Suffice it to say, for people who are not terminally ill, we have a different track in Canada. It takes longer. It takes 90 days. There's plenty of cooling off period available to you where you need to ask yourself whether or not you really want an assisted death or not. More experts are involved, all sorts of stuff. That's really all I want to say here. Well, maybe let me make one other point. There's something fishy about any jurisdiction that insists that patients need to say that their quality of life is unbearable. Because what does it tell you about a society that is telling people who suffer unbearably that they have to wait for 90 days? It's akin to saying, hey, torture is cool for the last 90 days of your life. But I have no answer to that, because I also appreciate the necessity to have safeguards in place, and that is a safeguard. There's no doubt about it. But if we take this seriously, this unbearable suffering, then what we are really asking people to accept is 90 days of torture until death will be available to them. So that is something I'm struggling with. Maybe it's something for discussion too, but so who is eligible today then? People with disabilities that do not make their natural death reasonably foreseeable are in fact today eligible for MAiD in Canada and are receiving it if they ask for it. Now, who was supposed to be eligible for March 2023? Canadians whose only medical condition is a mental illness and who otherwise meet all other eligibility criteria. However, politicians being politicians, so this is what happened. We got another bill, and then government kicked down the can on this to 2027, knowing full well there won't be government anymore. But that's what politicians do, so fair enough, leave it to somebody else. Ostensibly because the provinces were unable to prepare the healthcare system for this change. Now, the provinces at that stage literally had years to organize their healthcare systems and chose not to act. And then conveniently, it was impossible to do this. By that time, we had a parliamentary expert commission that had reported on this issue, so we had that information available. So we had really, people had plenty of time, that's what I'm trying to say here, plenty of time, and there was a decision not to do this. I think at the moment, this is how this is supposed to pan out, okay? Basically, there's a temporary exclusion of eligibility for MAiD for persons suffering solely from a mental illness until March 17, 2027, received royal assent, so in other words, it's the law. And this will allow more time for province and territories to prepare the healthcare systems as appropriate, which much evolves around the question of competency assessments, capacity assessments, not unreasonable. And for practitioners to participate in training and become familiar with available support guidelines and standards. The reason why I think ultimately this will happen is very simple. Even today, people with mental health issues or mental illnesses, including depression, who have decisional capacity, are able to access MAiD if they meet the other eligibility standards. Say, for instance, you could have depression, you had a capacity assessment, you are confirmed to have decisional capacity, and you also happen to die of cancer. Then these people's agency would not be removed. In other words, it is really just about people saying mental illness doesn't count in the same way, and the courts have dealt with that already. So it is for politicians to figure out now and regulators how they deal with this. Yeah, and this is how this looks like of course, in our media. Canada's very quick slide to approving euthanasia for the mentally ill, and Pierre Poilievre, who will probably be our next prime minister, a conservative politician, said, yep, it's not going to happen. It's not going to happen while I'm in government, so vote for me. And this is how this looks like in the Sun, which is the Sun like in Britain, basically. It's the yellow press. Killing off the sad and the poor with MAiD. Full comment by Anthony Fury. I don't know. All right, I'll leave it at that. What I want to say basically, and this is the main point, and I find difficult even arguing it because I think it's just stating a fact. There has been really no slippery slope in Canada. What really happened is that consecutive government bills took us to a situation where after the Supreme Court judgment came down, we had eligibility thresholds that were clearly too restrictive and unconstitutional. They were thrown out by the courts. Then a change of government, basically, a competent attorney general, a constitutional law expert from McGill, I think, yeah, McGill or University of Montreal, brought us basically closer to where our MAiD journey began in terms of the Supreme Court of Canada's access criteria. Now, you can have an argument about these access criteria, and that's a different argument. But I think what cannot be shown is that there has been some slippery slope of any kind in the country. And this was the objective of this talk. Nothing else. We can agree on, or disagree on most other things, but that I find just difficult to argue. And this is why I wanted to explain to you how these things evolved over the last few years and how it probably is going to continue. Thank you.